Okay, this is the third and last video lecture on the writings chapter of your book. We're covering authentication now, and I wanted to specifically cover both email evidence and website evidence, since these types of evidence are going to be more and more common as time passes. So starting here with email, and what I say about this actually also applies to text messages and instant messages and even chat room conversations as well, for the most part. Chat room conversations are often used in uh, child molestation cases for obvious reasons, since a lot of sexual predators try to meet underage people in chat rooms. So that's a really common type of evidence. So as you can imagine, as this technology started appearing on the scene, judges were very uncomfortable with emails as compared to hard copies of correspondence. The internet was a new and scary place. There were all kinds of fears about hackers and concern about the lack of any handwritten signatures, for example. So materials like these, they are usually proven at trial using computer printouts or electronic images, and there's usually no problem with presenting things that are printed out from a computer, just in terms of the item itself. And a witness can authenticate emails or messages he or she sent herself or himself. Or a witness can testify that he or she has received an email or received a message, but the problem comes in usually when trying to prove the identity of the author of an email or the sender of a message if the person that is claimed to have sent it won't admit sending it, or if that person is unavailable for some reason. So showing that an email came from a particular email address alone, and just showing that that email address is associated with a certain person, that is not going to be enough for authentication. Same thing with a text message. Showing that a text message came in from a particular number alone, also not going to be enough. So sometimes there's a witness who maybe will testify, say he saw the purported author type out and send a message or an email, or sometimes there's some other proof offered that a particular person was using, say, a particular computer at a particular time, that a message was sent from that computer. That is going to be a little bit more complicated. You might have to use an expert witness there who uses forensic techniques to trace messages back to a particular computer. But usually authentication of authorship is going to be done through the distinctive characteristic subsection of Rule 901, that one 901B4, okay, along with some evidence like, oh, this is a particular email account or particular phone number that was assigned to this particular person from which the message was sent. So there's going to be sort of a set of authentication evidence there. So under 901B4, distinctive characteristics here can be things like connections between statements in the communication and known facts about the purported sender, or maybe even behavior by the sender and the recipient, maybe something that they did after the message was sent that would lead you to believe that they, in fact, were the sender and recipient of that message, right? Their actions, say, after the message was sent, point toward those two people as having been the sender and recipient. Or maybe the messages in question fit into a larger course of conduct or a larger sort of set of communications between two people who regularly communicate that way. So it's usually something in the content of the message, sometimes combined with behavior of people. So also, don't forget these out of court statements, right? Emails, text messages, and the like, they're still going to have to get past the hearsay rules, either exempted as admissions or fitting within some exception, like maybe a present sense impression exception or excited utterance or something. There have, in fact, even been instances of a forwarded email being considered an adoptive admission of a person because the person passed on an email with just a cover note that indicated a belief in that underlying email's truth and an adoption of the content. Um, so that was sort of an interesting application there of the adoptive admission. Okay, so next let's talk about web pages, websites, and web postings. Of course, all of these are going to be subject to authentication too if a party, say, wants to use a printout or a printout of a screenshot as evidence. So just like with emails, judges in the early cases were very skeptical about this kind of evidence, but as it becomes more common, of course, courts are having to find their way here. One notable exception that I have on the slide to this authentication requirement seems to be government websites. So say a screenshot from a government website. Courts have interpreted those as falling under the self-authentication subsection of Rule 902. That's there in Rule 9025. 9025 refers to any publication purporting to be issued by a public authority. And courts have said, well, yes, this is this website that is a government website. We're going to interpret that as a self-authenticating publication issued by a public authority. But for non-government websites, well, now we can start there by looking at other kinds of evidence and try to extrapolate from other kinds of evidence to, say, a non-government website, because that's exactly what courts, of course, have had to do. So remember back when we were talking about authentications of phone calls. Remember, a phone call can sometimes be authenticated by showing that the caller dialed a particular number assigned to a particular person or business, and that combined with some other proof about that conversation, like self-identification of a person answering or just information about the substance of the call, was enough for authenticating a phone call. So here, if we extrapolate from that, say, to a business website, if you have a business website, for example, it's usually going to be enough to show that, say, a person found that website through doing some kind of search or by typing in a URL, went to the website and, say, placed an order or conducted business that would be expected to be conducted on a website like that. And if screenshots can be printed, things that are up on a company's website, like prices for certain products or warranty information, those kinds of things can be used as admissions in a case against the company. So a proponent wanting to authenticate a printout of a web page is going to have to show at least three things, and I have those on the slide here. So number one, they're going to have to show that the printout accurately reflects the computer image of the web page as of a specified date, which of course can be done through testimony of a witness. Second, going to have to show that the website where the posting appeared is owned or controlled by a particular person or entity, presumably the person or entity that the evidence is wanting to be introduced against. And number three, that the authorship of the web posting is reasonably attributable to that person or entity. So here's those 3 points up here on the top of the screen, and then I have on the bottom of this slide possibilities for corroborating evidence that could be provided to sort of meet all of those 3 points on the top. And that can come from testimony of people who saw the posting on the website, or by sometimes having the court go to the website if, for example, the website is still up and available to be seen, or finding somewhere else that this same information was posted or published somewhere else in addition to on the website by that same party. That would be good corroborating evidence to present. Also, there are some companies springing up out there that archive snapshots of websites as they appeared on certain dates. So you could have an expert witness, if you needed, testify to authenticate a screenshot image that purported to depict the appearance of a website on a particular date. So, as your generation of lawyers gets into the courtroom, I imagine that there are going to be more and more sophisticated ways to authenticate this kind of evidence. And judges are going to have to become educated, whether they like it or not, probably educated by the lawyers themselves. And eventually, I think the novelty here is going to give way to treating this evidence as somewhat routine. There are going to be sort of generally understood ways to authenticate it. But don't forget, once again, if the information on, say, a printout from a website is offered for its truth, it is going to be hearsay, so it does have to qualify for hearsay exemption or exception. And then lastly, I want to say a bit in particular about social media postings, which was the subject of the Griffin case that you read. So obviously the authentication issues here somewhat the same as with other electronic communications, but the big difference is that social media usually involves postings that are not going to be just between one person and one other person, like a text message or something, but instead they're going to be accessible to a lot of people, maybe even accessible publicly to the whole world. So even though it's not really clear that social media sites are more easily hacked than, for example, say email accounts, courts have had major concerns about security and about the possibility of malicious or fraudulent postings. And you saw some of that expressed there in the Griffin case. So just like with other forms of electronic communication, it's not a problem usually to show that a particular communication was received or posted on social media. But once again, the concern is showing the identity of the sender or the identity of the poster. So just showing that a message was sent from a particular social media account or posted on a particular page isn't necessarily going to be sufficient to authenticate. There's going to have to be more evidence showing the identity of the poster, for example, say specific evidence about the social media's site's security features, and a claim that those security features provided enough assurance of the identity of the source. Usually authentication here is accomplished again using that distinctive characteristics subsection in 901B4, like maybe showing that the messages were posted using code words that only would be understood by the parties alleged to be communicating. Or maybe there's some information in the posting that would only be known by the person that the proponent is attempting to link with that posting. And again, this evidence is the newest form that's appearing in cases, and courts have really ranged here from being quite lenient to being very, very strict in terms of how much circumstantial corroborating evidence they have required to admit printouts from social media. Courts don't seem to be going so far as to require, say, a representative from the social media company to testify about how the information is created and stored. And the other thing is, in the cases that I've found, sometimes it actually seems to depend who is offering the evidence. And not surprisingly, prosecutors are getting this evidence in more easily than defendants who want to offer it as part of their defense, just generally. But, if you see something like this on an exam, my exam, or the bar exam, again, there's probably not going to be a right or wrong answer about what a court is going to do, but certainly there's a lot to talk about there in terms of authentication. Okay, so lastly, let's talk about Rule 902, and it's a list of types of evidence that are considered to be quote unquote self-authenticating, right? Remember, if you want to proffer one of these kinds of documents, you don't have to present testimony or any extra extrinsic evidence of that piece of evidence's authenticity. So a lot of these items here in Rule 902 are public records types documents. For example, 902.1 covers federal, state, or local government documents if they are signed and if they bear the seal of the government unit. And similarly, 902.2 and 4 cover certified copies of official records. So now I'm putting this slide in here even though it's back from Rule 901. Why? Well, because 901.7 deals with public records as well. So as long as we're talking about public records here under 902 that are self-authenticating, I want to talk about the fact that 901.7 also allows for authentication of just a copy of a public record by that extrinsic evidence, by adding the testimony of someone that, say, a proffered record or a copy of a record was obtained from the public office where items of that type would normally be kept. And I want you to understand that this is a very common way to authenticate public records, especially nowadays since so many public records are available via computerized records. So just a printout would be offered in evidence instead of, say, a certified copy or something that's signed and bears a seal, so it would be self-authenticating. All right, so make sure you remember that Rule 902 isn't the only way to authenticate public records, that you can authenticate a copy of a public record with 9017 with some testimony about it. Okay, back to the 902 list. We see 9025 here regarding books, pamphlets, or other publications purporting to be issued by a public authority. I already talked about that one because remember, government websites have been considered by most courts to be self-authenticating under this provision. 9026 covers newspapers and periodicals, self-authenticating, but a big thing to note here, authentication of newspapers and periodicals alone is not going to allow them to be admitted into evidence. They are basically hearsay, and so will never or almost never be admitted for their truth because material in them is just never going to meet the requirements of any hearsay exceptions. And there's a lot of hearsay within hearsay in newspapers and periodicals. So make sure you remember that. And you should always sort of have a red flag in your head if you're given an example of a newspaper or periodical. Again, self-authenticating, yes, but admissible, probably not, unless there's a very peculiar situation presented. And the other one that's on this slide, another pretty obvious one, 9028 tells us that notarized documents are going to be self-authenticating. That is sort of the point, right, of getting your signature notarized on a document. Okay, next I want to talk about this 1954 Maine case, the Green Giant Company case from the note there in the book on page 684. So you saw the appellate court here in Maine upheld the trial court's exclusion from evidence of a can of peas labeled distributed by Green Giant Company because according to that court it wasn't sufficiently authenticated by the label, which is really kind of crazy. And the result in this case, I wanted to point out, would be different under Rule 9027, the federal rule in 9027, which specifically makes labels just like this and other trade inscriptions self-authenticating. So, of course, remember again, self-authentication just means that the can comes into evidence and the jury can then draw whatever inferences it wants to from the label. Green Giant, let's say this case was in federal court for some reason today, and it got automatically authenticated by Rule 9027, of course the Green Giant Company could still present evidence that the label had been forged or the label must have been transferred from another can, and the jury could still find that the can was not, in fact, a Green Giant can, but at least the label itself would be self-authenticating and get admitted. And lastly, Rule 902.11 and 12 actually provide a complement to the business records exception that at the time I'm taping this lecture, we haven't covered that yet in class, but they do complement the business records exception to the hearsay rule by making the records self-authenticating if in fact they satisfy the business records exception to the hearsay rule in Federal Rule 8036, and if they are certified by the custodian of the records or another qualified person. So 902.11, as you see, covers domestic business records. 902.12 applies to foreign business records, but only for civil cases only. Okay, so just to review, the rule about authentication essentially gets folded in to the whole laundry list of considerations as far as admissibility of a piece of evidence is concerned. Remember that authentication isn't the end of the possible questions about admissibility, it's just going to be the beginning. Other objections, especially the hearsay objection, may be available. However, in unusual situations, a party can jump more than one hurdle with the same testimony. And the best example of this is the one we just had, the complementary nature of the business records exception to the hearsay rule in 803.6 and the business records authentication under 902.11 and 12. And as we just saw, the standard questions that lay the foundations for the business records exception to the hearsay rule will also lay the foundation authenticating the records under 902.11 and 12. Okay, so I want to look at a quick and simple example. If you're practicing law, let's say you represent a tenant suing a landlord for violation of rent control laws, and you want to get entered into evidence a lease signed by your client, the tenant, and signed by the landlord. So the question is, how could you authenticate the landlord's signature on that lease? Well, I have 5 suggestions here on this slide. So first, you can use pretrial discovery, right? You can use that process, make a request for an admission by the landlord that the lease was signed by him, get it taken care of that way. And this is, authentication and best evidence issues are often taken care of before trial, either by a request for admission under the Federal Rule of Civil Procedure 36 or in a pretrial conference. In fact, if the other party refuses to authenticate unreasonably and you have to authenticate at trial, you can sometimes even get reimbursed for costs of having to jump through those authentication hoops. Okay, secondly, you also might be able to offer the testimony of a witness who saw the landlord sign it, or you can call the landlord as an adverse witness and ask him if he signed it, right? So both of those are covered by 901B1, right? The testimony of a witness with knowledge. Okay, or number 4, maybe you can offer a lay person handwriting testimony by someone familiar with the landlord's signature under 901B2. If there's somebody that was familiar with the landlord's signature outside of the context of this litigation, that person can testify, yes, I'm familiar with this gentleman's signature, and I think that this is his signature on this lease, right? Or the last one, you can provide expert testimony comparing the signature on the lease with a known exemplar of the landlord's signature under 901B3. Or you can even try to just admit into evidence exemplars of the landlord's signature and have the jury itself make that comparison. Okay, but also you can offer essentially circumstantial evidence for authentication in this case using your own client as a witness. So I want to go over a couple of ways you might do that. So maybe your client could produce the canceled rent check or security deposit check to prove that the landlord cashed it after the lease was signed. This is obviously circumstantial evidence that he must have signed it if he then went ahead and cashed that check. Or lastly, you might have your client testify that the landlord gave her the lease and told her, here's the lease, you go ahead and sign it and mail it to me, and I'll send you back a completed copy with my signature. And so your client could get up, testify about that. She could testify that she did sign and mail it to him at his business address and did in fact receive back in the mail the copy you are presenting in court. Again, all circumstantial evidence that could be used to authenticate that lease. So this concept of circumstantial authentication once again is usually held to be encompassed within that Rule 901B4, that distinctive characteristics subsection we talked about before, especially the part about the circumstances that led to your having the item of evidence. But remember too that those types of evidence that are listed there in 901B, they're not meant to be an exhaustive list. So you don't even really have to shoehorn those last two circumstantial evidence methods that I gave you into one of those 901 options, right? It just has to be enough to meet those requirements in 901A. Okay, and then I also have the last thing on this slide for this kind of authentication, circumstantial evidence authentication, you're probably going to need a combination of the contents of the evidence plus testimony about surrounding circumstances to get something authenticated. Okay, so the last thing on this video, I just want to talk about the cases in the book. I think they're pretty self-explanatory. I'm going to go over the first couple really quickly, starting with U.S. versus Dawkins on page 680. So this is a really picky authentication case written by a pretty famous judge, Patrick Higginbotham. This is another one of those Section 922 cases, like the Old Chief case, where one of the counts against the defendant Dawkins here was being a felon in possession of a firearm. So to prove he had a prior felony conviction, you saw that the prosecution offered an exhibit here, which was a fingerprint card and police record sheet that was claimed to have come from the Denver Police Department. By the way, on this slide, that is not Dawkins or Smith's 10-print card that's on the slide. It's actually John Lennon's 10-print card from his application for permanent residence in the U.S. Just have this on the slide here to show an illustration of what an old school 10-print fingerprint card looks like. But the appellate court here in the Dawkins case held the documents here were not self-authenticating, that they weren't in fact properly authenticated by the prosecutor at all, even though the court says, look, this error was harmless. So Dawkins still sort of loses in the case. I call it a pretty picky case because really, what are the chances that a document purporting to be a fingerprint record from the Denver Police Department is actually a document from another source? Maybe pretty small chance, especially when you consider the basic liberality of the requirements there under 901A, but it still does miss fitting in under one of those 902 self-authenticating examples, right? Because there was no seal, there was no certification of an authorized person. And the appellate court here says, look, the prosecutor just didn't try hard enough here. And maybe there is value in requiring that the prosecution should have to produce more evidence than it produced in this case, since, prosecutors' offices do have a lot of resources. They could have avoided this authentication problem here in the case by just preparing well in advance and having their ducks in a row. Okay, so here's a little multiple choice question to test whether you actually read this Dawkins case. So in Dawkins, the prosecution could have properly authenticated the fingerprint card. How? And here are some possible ways. By, number one, offering testimony by a Denver police officer who was custodian of the record. Or two, introducing a certified copy of the letter. Or both, one and two, or either or. Or number four, offering testimony by a local police officer that he had called the Denver Police Department, requested the fingerprint card, and later received it in the mail. Or maybe number five, all of the above. So what's the answer? Well, the answer is five, all of the above, right? All of these were described by the court in the excerpt in your book as ways the prosecutor could have authenticated in the Dawkins case. All right, next we have U.S. versus Hampton, page 682. This is our friend Judge Posner on the Seventh Circuit, and here we have a federal prosecution for bank robbery. The defendant here was a serial bank robbery, and an element of the crime charged was that the banks had to have been federally insured at the time of the robberies, right? That's how they got a federal charge in the first place. So to prove that, bank employees testified that they recognized documents that were shown to them by the prosecution as being copies of the Federal Deposit Insurance Corporation certificates that had been posted on the walls of the bank where they worked. Those documents weren't self-authenticating under Rule 902.1 for signed and sealed documents or any other certification provisions because they were just copies, right? Not the certified documents themselves. But Posner here says, look, you don't have to fit within one of the particular examples in either 901 or 902 to pass muster here. You just have to provide enough evidence under 901A that the evidence is what the proponent claims it is. So I have on this slide a notable quote from Posner's opinion here. As between the parties' rival hypotheses, number one, that the parties are genuine, as the government contends, and that, or number two, that they're forgeries, as the defendant contends, the defendant's hypothesis is so improbable that without some evidence to support the hypothesis, no reasonable person would accept it. Okay, so under 901A, the proffering party only has to provide evidence that's sufficient to support a finding. And Judge Posner says, well, yes, the government's work here was really sloppy, but it was good enough to survive appeal to the Seventh Circuit. Okay, next let's look at this First State Bank of Denton versus Maryland Casualty Company, a really interesting case about a phone call there on page 684. So the plaintiff here is a bank. The bank was the executor of the will of J.T. Mills, right? And the bank was suing to recover on a fire insurance policy after a house that Mills owned burned down. So the fire happened when Mills was still alive, but now he's dead, and the insurance company is his executor. The bank is his executor, and the insurance company has refused to pay on this policy. So the insurance company defended the case on the grounds that J.T. Mills had set the fire himself. And the bank had lost at trial. And on appeal here, the bank argued, look, the trial court should not have admitted a phone conversation between a police dispatcher and an unknown man at the home Mills was living in at the time his old house caught on fire. So the insured dwelling here was Mills' unoccupied first house, and the fire started very late at night. So at trial, part of the evidence that Mr. Mills had set the fire himself that was offered by the insurance company was this phone call. The insurance company wanted to show that Mr. Mills wasn't at his new house at the time of the fire, i.e., therefore he might have been out setting the fire. And the evidence the company proffered was that at 1 a.m., about 15 minutes after the fire started, a police dispatcher called Mills at his new house to tell him that the old one was on fire. And the dispatcher testified at trial that an unidentified man had answered the phone by saying, "This is the Mills residence." And then when the dispatcher asked for Mr. Mills, the person purportedly said, "J.T. Mills is not at home." Not conclusive evidence, but it could show that he had had the opportunity to be at the old house setting the fire if he wasn't home at 1 a.m. So clearly the authentication issue here was whether the person was who he claimed to be, that is, someone answering the phone at the Mills house. All right, so we know that you have to authenticate phone calls just like you need to authenticate documents. Rule 901B has that example about phone calls, so we could start there. Now, this wasn't a call to a business, so Part B is out. It would have to fall under 901B 6A, right? A call made to a number assigned at the time to a particular person, which was established here. The dispatcher testified she called the number assigned to Mills at his new house. But where we run into trouble is this example in the rule requires that the person answering identify himself as the person to whom the phone number was assigned, or it has to be shown by some other circumstance like voice recognition if the person calling knew the person answering the phone. And we don't have that here. Okay, so the requirements of 901B6 have not been met. So what does the appellate court say, though, here about how this phone call could have been authenticated? Well, the court says, look, those authentication examples set forth in Rule 901, they're not meant to be exclusive. They're just illustrative of the kinds of authentication evidence that would be acceptable. So Denton here really is a case of circumstantial authentication, just like in my example, those circumstantial authentication ideas that I gave you about how you could authenticate that lease for your client. Okay, so when the dispatcher called the number listed with the phone company and got someone who said it was the Mills residence, that was sufficient evidence to support a finding within the meaning of Rule 901A that the person answering was in fact in the Mills residence. In fact, it's actually kind of improbable that the dispatcher could have called the wrong number and then gotten a person who answered and falsely said, "This is the Mills residence," right? And furthermore, who went on to say that, yes, J.T. Mills lived there but wasn't home. Okay, so the court said enough authentication evidence was provided here. Okay, but there is a good hearsay review issue here in this case. So there was also a hearsay argument that was raised by appellants here. And so the question is, how did the evidence get past that hearsay argument? So I wanted to work through that together. So first, is it hearsay? Is the statement, J.T. Mills is not at home, offered for its truth? Well, yes, it is. J.T. Mills is not at home is being used to prove exactly what it asserts. So it is hearsay. It is being offered for its truth. How about a side question next? Is the statement testimonial? No, it doesn't appear to have been made with any expectation that it was creating evidence of any kind. Okay, so it's not testimonial, but it is hearsay. So next we want to ask, does a hearsay exception apply? And if so, which one? Now, hopefully some of you got this one. It, I would say, is a present sense impression. The unknown declarant here was perceiving at the very moment of making that statement that J.T. Mills was not at home. Now, we do have to note here that for the present sense impression exception to apply, we have to remember the requirements of that exception. The person actually has to have looked for Mills right before making that statement, because it's not going to qualify as a present sense impression if the declarant, say, had just woken up because the phone was next to the bed, it's 1 in the morning, and maybe that person was just remembering that at some earlier time J.T. Mills had gone out and wasn't home, right? But in the actual case here, the dispatcher did ask the person who answered the phone to go and physically see whether Mills was there. And then the person had left the phone apparently to look for Mills and then had returned to the phone saying that Mills wasn't home. Okay, so in the hearsay portion of the opinion, in this case, the court held that the present sense impression exception requirements had been met. And in fact, they also went on to say, and besides, we would also have admitted this under the residual exception. Both applied in this case. Okay, and the last case in this section, Griffin versus State, this Maryland Court of Appeals case. This is a fun one for getting into the difficulties posed by computers and the internet and social media, texting, and so on. So Griffin here being tried for homicide, the state offered and the trial judge admitted evidence of what the state claimed to be that MySpace profile, a printout of the MySpace profile of Griffin's girlfriend, Jessica Barber, which contained a posting that appeared to be a threat against a prosecution witness. Free boozy. Just remember, snitches get stitches. You know who you are. So like I said, presumably these were screenshots that had been printed out. A police sergeant there testified that he found the profile by going to MySpace. And the prosecution argued that the photo on the profile, which appeared to show Barber and the defendant together, and the fact that the birthday and hometown on the MySpace profile matched up to Jessica Barber. And they also were looking at the threat itself, which referred to Griffin by his nickname Boozy. The prosecutor argued, look, these are all sufficient circumstantial indicators for authentication that this was Jessica Barber's MySpace page and that Jessica Barber actually posted this. Griffin, on the other hand, argued, no, that wasn't adequate because anyone could go on MySpace and create a profile in someone else's name, and anyone with knowledge of some information about Barber, access to that photo in question, could have in fact framed Barber and indirectly also framed Griffin by creating the profile and posting this threatening message. Or even the alternative argument here, even if it was Barber's profile, anyone who got access to her username and password somehow could also have posted the threat. So you saw that the two dissenting judges in this case call all of these concerns technological heebie-jeebies, right? That should only have gone to the weight here rather than the admissibility of the evidence. But as you saw, the majority here held that the evidence hadn't been adequately authenticated. So the majority opinion actually reviews quite a few different cases in this area, which I think makes it a good review and certainly a good case to review before the final and before the bar. So the court here, the majority lists at least four possible methods that I could pull out of the case that the prosecutor maybe could have tried to use here to authenticate. So first, the prosecutor could have called Barber to the stand and asked her whether it was her profile and whether she had written the post. This is certainly going to be the most straightforward way, right? She's going to be under oath in this scenario, so maybe she'd just admit it. Yes, I did make this post. I did try to intimidate a prosecution witness. Maybe, right? But next, number two, the court says law enforcement could have maybe gotten a warrant to seize and search Barbara's computer. Presumably, her computer would have left a trail if she created the profile and posted the threat. But this would probably be obviously very expensive, very complicated. It's also possible that she could have used a different computer for this purpose. So it's possible that she would have thought ahead about covering her tracks, but still, it would have been a method to try. Okay, next, it's possible that by searching the entire profile, the prosecutor could have found some more distinctive characteristics, maybe even more personal information that only Barber could know, something beyond the basics like birth date and hometown. So essentially just gathering more circumstantial evidence. Now, it's possible the court would have been convinced, even though that would still leave open the possibility of someone hacking into Barber's account to post this exact threat, notwithstanding all this additional other evidence. So it would really depend on whether the court's concerned about this hacking possibility would have caused it to not let the evidence be considered authenticating. In any event, this possibility of hacking really seems like something that should go toward weight, though, and not authentication, not keep this evidence out on authentication grounds, since it's supposed to be a very low threshold. And I suspect that, in fact, most courts, especially nowadays, are going to find a way to let this in. So Griffin, maybe in this circumstance, might be considered kind of an outlier case. One case the prosecution tried to rely on here was the instant messaging case on the bottom there of page 692 and the top of 693. In that case, you saw the court held that the instant messages were sufficiently authenticated by those distinctive characteristic, right, the circumstantial evidence that was provided. But the court here says, well, no, that case can be distinguished from the facts here. The court says by, looking at the fact that those messages were authenticated by testimony of one of the people who participated in those conversations. And the guy who was the threatener in that case had in fact admitted his real first name, talked about the fact that the victim had told the school principal about his threats, and so on. So that was a two-way communication, versus here in Griffin, the officer testifying, of course, didn't do any interacting. He just testified, well, I went to MySpace and I found this page, this is her picture, this is her birthday, and so on. All right, and then the last alternative the court suggests, kind of vaguely, is to just try to get evidence somehow from MySpace itself, citing another case in which the prosecution had relied in part on that kind of proof. But the court here doesn't go on to try to explain how anyone from MySpace is going to determine exactly who was at the computer when the profile and posting were created in the first place. So it might be questionable in this context. I mean, I would say if you end up with something like this on an exam, you're going to want to be creative. You're going to want to come up with as many ideas as possible, knowing that with this kind of evidence, courts have reached different decisions with fairly similar facts. Okay, so that is the end of the 3 video lectures on this writings chapter in your book.